Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have a strange case out of the Eastern District Court of Appeals of Missouri, and it's unique. I'll say that for it. Now, a lot of what I'm going to tell you here is supposition and opinion. A lot of it is not facts. The facts we're going to get out of the opinion, and hopefully we'll get a better understanding. But this is a really interesting case. And it's funny at one level because of what happened, but it's not funny at another level because clearly somebody's hopes were dashed. The chance to father a child was lost. Apparently, the husband and wife had tried to get pregnant, and they had not met with success in the way that people normally get pregnant, which is by accident. Reading between the lines in the opinion, it appears that the husband is the one who had the problem because his sperm had low motility. But it is a case of a spouse being super sneaky about what she did. And it's interesting that they filed this claim against the doctors instead of against the ex-spouse. So I want you to understand, I'm not poking fun at the husband. I'm not poking fun at the wife. I'm not poking fun at the surrogate in this case. I'm really just kind of poking fun at the whole way this thing came down and the fact that the lawyers didn't catch the key facts that are at issue in this case. So let's take a look at the opinion. This is an appeal through the Missouri Court of Appeals, Eastern District, and it's from CH and SS. CH is the husband, SS is the surrogate who gave birth to the child, against the Infertility Center of St. Louis, among others. So this matter involves the trial court's grant of summary judgment in favor of Semen Silber. And as I've said on numerous times on this channel, summary judgment is about avoiding trial by showing that the facts are undisputed and that they're entitled to judgment as a matter of law. Well, the first thing they say is, look, you filed this beyond the 2-year date for the negligent occurrence, which is this 516.105 statute in Missouri, which gives you a 2-year statute of limitations in which to file a medical negligence claim. And the incidents that occurred here occurred in 2009, and they didn't file this complaint until well after that, I believe in 2019. So the appellants assert the trial court improperly granted summary judgment because it falls under an exception to the statute, and the 2-year statute has an exception for negligent failure to inform somebody of test results. But when you get right down to it, this is probably, I am really surprised that they appealed this case because they are on very tenuous footing here. Well, the respondents answered and they said, look, no malpractice occurred, the claims are time borrowed, and the issue here is the person knew or should have known what the facts were. So here are the facts. CH, the husband, and PH, the wife, were married at the time, went to the IVF clinic to see if they could get an embryo transplant into a surrogate, because apparently they didn't realize whether it was the husband or the wife who couldn't conceive. So they contacted a surrogate, and the surrogate agreed to give birth to their baby. On October 23rd, the wife delivered a semen sample that she said belonged to her husband to St. Luke's. In November of 2009, and again in February of 2010, Dr. Silber fertilized 3 eggs from wife with the semen sample that she had provided. However, the semen sample was from her paramour rather than her husband. And apparently the husband didn't recognize this. So Dr. Silber met with the husband and wife on November 6th of 2009 and February 2nd of 2010 and March 11th of 2010. And during those meetings, he explained that he had created 3 embryos in November of 2009 and an additional 3 embryos in February of 2010, utilizing the previously frozen sperm that the wife had provided in 2009. That same day, husband and wife said, go ahead and transfer him into the surrogate at the first opportunity. And that was in February of 2010. Appellants alleged that sometime in March of 2010, the husband provided his own semen sample at the request of the respondents. Now, if you are suddenly going, now wait a minute, didn't he say that the eggs were fertilized in 2009? Yes, that's exactly what happened. The eggs were fertilized in 2009, so if he had not given a semen sample before that time, there is no way he couldn't have recognized that the semen used was not his. But for whatever reason, according to his pleadings, he didn't know that. In July of 2020, Dr. Silber transferred the embryo into the surrogate, who later gave birth to a baby boy. And then in 2011, husband and wife retained the services of a Tennessee attorney and filed a petition to establish parentage and custody against the surrogate because they were afraid the surrogate wouldn't give up the baby. In October of 2009, and this is what the petition said, among other things, in October of 2009, husband's sperm was produced and then frozen at St. Luke's to be used for all IVF procedures, and an embryo fertilized and frozen in 2010 using that semen was transferred to the surrogate in July of 2010. Well, the husband in 2 sworn statements and the surrogate in verified interrogatory answers confirmed the information set forth in the petition to be accurate. Furthermore, the husband's attorney approved and the surrogate accepted the Tennessee court's March 10th order of 2011 granting the custody of the child to the husband and the wife. In October of 2019, the husband and the surrogate filed a medical malpractice action against Dr. Silber. They alleged the respondents were negligent in providing IVF treatment using sperm that was not the husband's between 2009 and 2010. Now you'll notice who's absent from this lawsuit, and that's PH, the wife, which I guess now is the ex-wife. And it's just the husband and the surrogate. And the surrogate's claim is, hey, I didn't give permission to have somebody else's kid implanted into me. I gave permission to have the husband's kid planted into me. Well, the petition says there were a lot of breaches of duty, and as a result of that, the respondents moved for summary judgment, arguing the claims were time barred, that's 1, no malpractice occurred, that's 2, and the husband and surrogate should have known or had reason to know that Dr. Silber used a prior frozen semen sample, which was not the husband's, to create the embryos. And the trial court granted that summary judgment, and so they appealed. And then the court goes through the standard for summary judgment, which is that as long as the facts are uncontroverted, you can establish a right to judgment as a matter of law, then you're entitled to summary judgment. And it says, we'll affirm summary judgment by any appropriate theory supported by the record. And that's what they've done. So they talk a little bit about some of the facts in the case, and they say to survive summary judgment, husband and surrogate must present facts supporting a finding that respondent's failure to inform husband of his sperm motility test result was the cause in fact and the proximate cause of their damages. Well, they failed to do so here. They focus on a number of the acts, but the one act that they focus on most closely was the failure to inform husband that his sperm had low motility and therefore could not be used successfully for in vitro fertilization. But the fact is, it could have been used for in vitro fertilization because, as they point out down here in footnote 5, they used a technique called intracytoplasmic sperm injection, ICSI, to fertilize the eggs, where sperm motility doesn't have anything to do with it. So the damages husband and surrogate alleged they suffered as a result of not being informed of the husband's test result stem from their unawareness that the genetic material used for the IVF process belonged to another man. But the test occurred after the fertilization, so it can't possibly be linked to that. And indeed, that's what happens here. They go down and they say the uncontroverted material facts in the record make clear the husband was provided ample opportunity, apart from the motility test, to know the semen sample used to fertilize the embryo transferred to surrogate did not belong to husband. Most notably, the petition to establish parentage in Tennessee, where they used Dr. Silber's sworn statement that he used the October 2009 sample and not some sample from later on to establish the fertilization of the embryos. So here's what the court says, and I've starred this because it's important. Appellant's petition asserts they were unaware that there was a previous sample, but how could they be when they put into their petition in 2009 that Silber created the embryos in 2009? If they created the embryos in 2009 and the semen sample wasn't provided until 2010, unless someone is suggesting that St. Luke's has a time machine, that timeline just doesn't work out. And you wonder how in the world the lawyers who were drafting this appeal didn't figure this out. But they didn't. Here, I don't mean to cut in, but I thought I would tell you that I would really appreciate it if you haven't already subscribed to this channel. Please do so, and please leave a like on this particular video. It's very important. It helps make sure that YouTube knows this is valuable content and will recommend it to other people. That's it. That's all the commercial. Back to the video. It's undisputed that Dr. Silber met with the husband on November 9, 2009, February 2, 2010, and with both husband and surrogate on March 11, and informed them that he created the embryos in 2009 and February of 2010, utilizing the previously frozen sperm wife provided in October of 2009. Additionally, husband's statements in the record regarding his March 2010 sample indicate he provided the sample in a medical facility, not that he provided the sample to the wife to be delivered to Dr. Silber. Appellants should have known, or had reason to know, Dr. Silber used a sample other than husband's to create the embryos. And Dr. Silber's sworn statement provided that a frozen sperm sample from October 2009 was used to create embryos that were later transferred to surrogate. That was what was wrapped up in the Tennessee case. So again, the record and the judicial acts that were taken in Tennessee confirm that the husband had every opportunity to know. Husband had multiple opportunities to realize the genetic material used to create the embryo transferred to the surrogate could not have been husband's, because it both predated the lone sample husband claims he provided in March, and because it was delivered by wife rather than collected from husband at the facility. Surrogates' claimed damages are tied in appellant's petition and in their argument on appeal to husband's knowledge. Thus, surrogates' claimed damages are also negated by the undisputed facts that husband had reason to know in 2010 that the sperm Dr. Silber used was not the husband's. So I'm going to speculate here. And here's what I think probably happened. At some point in time, the wife was fooling around with another guy, decided that she really didn't want to have a child with her husband. She really wanted to have a child with somebody else. So she went to somebody else and got a semen sample and decided to get pregnant with that semen sample. She never told the husband. At some point, the husband apparently stumbled onto this, either in going through the medical records or otherwise, perhaps in the divorce, because it's pretty clear that the two of them got divorced at some point, and maybe in that process, the husband learned, hey, this isn't your kid. You don't have to pay child support because he's not your kid. And we can prove it with DNA. And maybe that's what happened. Maybe they got a DNA test and it confirmed the fact that this was not his child. So then they pieced it together and filed this medical negligence action. This is another case of the lawyers involved not looking at the law before they filed the case, and also targeting the wrong defendant. Because when you receive a semen sample from the wife, if you are a doctor, you have every right to believe that it came from the husband. especially if she tells you that it came from the husband. You certainly do not expect that the wife would tell you something that wasn't true. Here's my husband's semen sample. You would expect that that would be true. Only in this case, it clearly wasn't true. And so it seems to me that if somebody was going to be sued as a result of this, it should have been the wife. But here's the problem. My guess is in the divorce, all of the claims that the parties had against one another were probably released in the judgment and decree. So if this was going to be brought, it would have been brought at all during the divorce. And as a result, the primarily guilty party here, the wife, was home free. Sometimes it's a crazy way the law works, where as a result of a number of things coming together, the other guy gets away with it. And that's just the way things work sometimes, and you have to take the bitter with the sweet. So that's the case of the spouse's sneaky semen sample substitution case. I hope you have found it as interesting as I did. If you have the opportunity today, do something nice for your husband or your wife. This is one of those things that illustrates that when you're in a relationship with someone that you love, you have to work on it. You have to work on it on a daily basis. And if you don't do that, pretty soon people do grow apart. And they start looking for fun and excitement in other people's arms. As a result of that, it is just a very good idea to spend a lot more time working on your marriage than doing other things that maybe you might enjoy at least as much, but may not pay off as much in the long run. Thank you so much for watching. If you have any comments, leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. Thank you for watching, and catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.